What is the relationship between administrative law and constitutional law? Administrative law and constitutional law are two closely related branches of public law. While constitutional law lays down the basic framework of the state by establishing its organs and distributing governmental powers, administrative law regulates the exercise of those powers by administrative authorities. Constitutional law provides the foundation, whereas administrative law ensures that governmental powers are exercised fairly, reasonably, and within legal limits. Therefore, both branches complement each other in maintaining constitutional governance and the rule of law. Distinction between constitutional law and administrative law. Although both branches belong to public law, they differ in their nature and scope. Constitutional law deals with the structure, powers, and functions of the legislature, executive, and judiciary. It defines the relationship between the state and citizens, guarantees fundamental rights, and establishes constitutional limitations on governmental power. It is regarded as the supreme law of the land because all other laws derive their validity from the Constitution. Administrative law, on the other hand, deals with the organization, powers, functions, duties, and control of administrative authorities. It regulates the day to day functioning of government departments, statutory bodies, public corporation, and administrative agencies. Its primary objective is to ensure that administrative authorities act according to law and do not misuse their discretionary powers. Thus, constitutional law creates governmental institutions while administrative law governs their administrative functioning. Similarities. Despite their differences, constitutional law and administrative law share several common features. Both are branches of public law and regulate the exercise of governmental power. Both seek to protect the rights and liberties of individuals and ensure that public authorities function within legal limits. They are based on the principles of rule of law, natural justice, judicial review, and constitutional supremacy. Further, both branches derive their authority from the Constitution and work together to promote accountability, transparency, fairness, and good governance in a democratic state. Interrelationship. The relationship between constitutional law and administrative law is both close and complementary. Constitutional law provides the legal foundation upon which administrative law is built. The Constitution creates the executive and defines its powers, while administrative law regulates the manner in which those powers are exercised. For example, the Constitution guarantees fundamental rights and empowers administrative authorities to implement laws. Administrative law ensures that while performing their duties, these authorities do not violate constitutional rights or exceed the powers granted to them. Therefore, constitutional law provides the source of administrative power, whereas administrative law regulates its exercise. Constitutional control over administration. The Constitution exercises effective control over administrative authorities through various constitutional provisions. Article 14 prohibits arbitrary state action and guarantees equality before law. Article 21 requires that every administrative action affecting life or personal liberty must be fair, just, and reasonable. Article 32 empowers the Supreme Court, while Article 226 and 227 empowers the High Court to issue constitutional writs and exercise judicial review over administrative actions. In addition, constitutional principles such as natural justice, rule of law, separation of powers, and judicial independence ensure that administrative authorities remain accountable and function within constitutional limits. Thus, the Constitution acts as the supreme control over administration. Administrative law as a tool for good governance. Administrative law plays a vital role in promoting good governance by ensuring legality, accountability, transparency, efficiency, and fairness in public administration. It regulates the exercise of administrative discretion, controls abuse of power, protects citizens against arbitrary action, and provides remedies through judicial review and administrative tribunals. Administrative law also facilitates effective implementation of welfare schemes, public services, environmental protection, consumer welfare, and economic regulation. In a modern welfare state, administrative law has become an indispensable instrument for achieving responsible, transparent, and citizen oriented governance. Conclusion. Constitutional law and administrative law are inseparable components of public law. While constitutional law establishes the framework of government and guarantees constitutional rights, administrative law regulates the exercise of administrative powers within the framework. Together, they ensure lawful administration, protection of fundamental rights, accountability of public authorities, and effective democratic governance.